Hello, hello. Hey, y'all, it's David with I'm So Offended. Got a series of a few videos I'm gonna put up here. As I mentioned to y'all, I was doing a custody thing, and so I filed for modification, basically, is what I did. And I'm gonna show the documents, what was filed against me, core everything, the whole entire process. Okay, the whole thing. Um, First, I'm not an attorney. I don't practice law. This is not legal advice. Anything I say on here is for informational and educational purposes only, for entertainment use. I'm not liable for anything that you do in any way, shape, or form. I'm merely just showing examples of things that I've done, that I did, that I am allowed to do, and yeah. So um, I'll just state, hit me up and contacting me dynamic at hotmail.com. That's DIENAMIK at hotmail.com. I'll respond with a series of questions. And then, from there we go from there. You know what I'm saying? I'm here to basically just state what I would do in your situation if you message me. I don't give legal advice or anything like that. I just if you tell me what you have going on, all I'm gonna say is, hey, this is what I would do in that situation. And I would kind of try to direct you towards the path that I would take if I was in that situation that you explained to me. Okay, but it's very important that you show me your paperwork. If I don't see paperwork, I have no idea what's going on. All right, paperwork is important. Okay, so this is what I did. I filed for a modification of custody and legal decision making. Now, I knew I wasn't going to get everything I wanted. I knew it. I knew it. But the thing is, you hit absolutely zero home runs if you don't swing for it. Okay? Because at minimum, it'd be great if you get a base hit, two bases, three bases. We would be happy with that. You just want a hit, right? But you don't walk up to the plate just looking to get a hit, unless it's strategy and you're, you know, going to go for a bunt in order to bring someone else in. But for this analogy, you swing for the fences, right? Which means you got to swing hard, which means you might get a strikeout, which means you'll get balls. But you swing for the fences because if you make contact, even if it's not at the right part of the bat, you'll get a few bases out of it. So that was my strategy going into this. I knew I wasn't going to get legal decision making. I knew I wasn't going to get equal time, but I was going to make them fight me for it, fight me over it. So that's what I did. And what I used, I just used the court paperwork. Yeah. All your courts have forms. They have ready-made forms, and if they don't, there's universities close by. They all have like some kind of link. I spoke to a guy. I don't remember if it was Pennsylvania or in Georgia, and his court didn't have pre-filled out forms. And then all I did was did some Googling for him, and I was able to find, like, oh, look, your university right here through a link on the court website does have these forms. So I guess it was like a university that has like a law program, and in that university they have the pre-filled out, approved by that superior court, by those courts, forms. I'm like, here you go, here you can get your forms, and it had the whole list of forms. So I used the court forms. Why? Because it's simple. They're already pre-made for you. Okay, and they follow the statutes. Sure, you can make your own thing. You got to make sure that you know what you're doing. I know what I'm doing, except I still used their forms, and all I did was attach my own parts to like fill it, and my own affidavits and things like that. Those things I created. Especially when you want, because you need so much room to fill out the paperwork, right? So anyway, so all I did, it was simple. It was simple, and it's simple to me because I get it. So to those of you, I don't want anybody to feel like I'm insulting you in any way, shape, or form, because there was a time when I didn't know, when I had no idea. So that's why I'm going to walk you through how to get there. So what I did, so I know the statute. I know the statute is 25-411 in Arizona. But it's all a best interest statute, and then you just put in modification, or you put in for custody, or whatever it may be, and it applies to every state. And I'll prove it to you, all right? Pennsylvania, for instance, family best interest statute custody. There it is, right there. There's your best interest factors, and there is your statute. That's all you have to do. Google is your friend. All right, and that works for every state. So that's all I did. So I knew the statute already. I had just put in, Arizona best interest statute. There's the rules as far as best interest statute, what you're supposed to do here. And how they decide. So it's supposed to be, let's see, there it is. First line. A person shall not make a motion to modify legal decision-making or parenting time decree earlier than 1 year after its date, unless the court permits it to be made on the basis of affidavits that there is reason to believe that the child's present environment may seriously endanger the child's physical, mental, moral, or emotional health. You see that phrase? Seriously endanger the child's physical, mental, moral, or emotional health, right? And that's where you get into your Rule 48, Rule 49, where you have the temporary orders. And I know a lot of you have experienced that. Oh, I just realized that I was in the way of, and you guys couldn't see that because my face is in the way. Let me move my face. There it is. Then 1 year after its date, unless the court permits, made on the basis of affidavits that there is reason to believe the child's present environment may seriously endanger the child's physical, mental, moral, or emotional health. So that's how they do, again, the temporary orders. And so then the rules that have to be filed, that have to be used is, now this is here at the bottom. So it's part L. Let me get to that. I have to do it like this in order to see it. Okay. To modify any type of legal decision-making or parenting time order, a person shall submit an affidavit or verified petition setting forth details, facts supporting the requested modification, and shall give notice. I'm reading paragraph L. Together with a copy of the affidavit or verified petition to the other parties to the proceeding who may file opposing affidavits, the court shall deny the motion unless it finds adequate cause for hearing. The motion is established by the pleadings, in which case it shall set a date for hearing on why the requested modification should not be granted. All right. So there it is. It's telling you the rules. The rules are there for you to use. Okay, and I keep telling you guys, use the rules against them. These are the rules that I used for my modification. Okay, so I got the court petition. It's what I used. Court's own paperwork. And I just went down the list of legal decision making, best interest of the child. Because I told you, all custody is based on best interest of the child. So, like I just showed, you Google family best interest of child, and then you get the factors that are considered. All right, so let me move out of the way here. We're going to jump back and forth. This is what I had to follow, and this is what court orders are made of. All custody orders are made through the best interest factors. So here's what I did. So I went down the list. Here is my, let's get it here. me see if that one's the one. Let me find the one that is the one. Alrighty. So here it is. This is what I followed. And I don't know if I've told you guys before, but this is what Rick W.'s paperwork got me. This up here at the top. This thing that says, notice this document is subject to the court's March 7, 2018 ruling designating the filer as a vexatious litigant. That's what Rick W.'s paperwork got me. It got me called vexatious litigant for filing his documents. You see that? That's what I got. So anyways, right there. So let's continue. This is what I filed here. This is what I'm proposing. This is what I attached with the court standard petition. So I attached this, and I put together, father shall have legal decision-making the authority in the event mother takes mental health evaluation and parenting classes, focus on co-parenting, and court awards legal decision-making, fathers shall have final say. So this is just me saying what I think should happen. Mother's entitled to all information. Exchanges shall occur at the police department. There you go. Move myself back up here. All right, absent an emergency situation or act of God or joint written agreement, custodial interference for sanctions. Basically, you just have to be very specific. Emails for exchange. Neither mother may father may move, relocate daughter out of state. Absent court order. Everything is broken down, even numbered years, rodeo, spring break, summer break, everything. So I was very specific here. Tuesday to Sunday. I'm basically going for like a week, 2-week thing. Labor Day, Halloween, daughter birthday, Thanksgiving, all of this. I'm sure you guys have seen it. You can put this together. It just takes time. You can do it. Okay, odd numbered years, rodeo vacation, spring break, summer break, everything. I wrote all of this up. I was just very specific. It's like I made a schedule for the entire year. You got to do it. You got to do it. And you got to follow it. If you're going to make the schedule, you got to follow it. I get it. You have work. I have work too. But you got to follow it. Okay? Thanksgiving, Christmas break, exchange information, all of that. All of that was on here. Traveling, everything. And then I offered a couple of different plans. So there's my exchange. That's what I did. That's what I followed. Right? This is the parenting plan. That's what I followed. That's what I submitted. All right. And there's my petition. So in my petition, all I did was follow the rules. Okay, that's where I mentioned we're going to go back and forth a bit. Okay, so since the last order of modification time, father has done supervised visits. I did supervised visits for 10 months. All these detailed reports from the supervising agency. I'm telling you, though, what they want is evidence. They don't care that you're a great father. They don't care. They don't care. They don't care. They don't care. They just want evidence, and we show evidence. But the thing is, what I've noticed is that I've gotten treated differently. I get treated differently because I'm not playing their game, because I don't have an attorney, and I'm able to do what I'm able to do without the hundreds and thousands of dollars of law school like they all went to. The judge they don't like it. They don't like it, and I know it because I get treated differently. I have a freaking magnifying glass on me, and every single stupid mistake, I cough the wrong way or fart too loudly, and they're going to deprive my child from me. That's what they do. They don't care. Whereas the mother has failed to follow the order 3 times now. They keep filing all these frivolous things, and they lie. There's no such thing as perjury in family court. I want you to know there's no such thing as perjury, because I caught her again committing perjury. She just lied and lied and lied and lied and lied and lied, and then they did nothing about it. So I definitely get treated differently. So be prepared for that. Be prepared for that you will be treated differently because you don't have an attorney. Even though you could follow all the rules and do everything right, they treat you differently because you're not playing their stupid little game the way they want you to. All right? So, I mean, I'm playing their game because I'm following their rules, codes, and statutes. I'm playing their game. Yeah. But I'm not playing it participating in their little club of attorneys and judges and all of that. I'm not participating in giving them money. Okay, they get nothing from me. So here's best interest factors, and it all relates to frequent, meaningful, and continuing contact is not only appropriate but necessary. This is the language that I used. I'll pause it. I'll give it a few seconds so that y'all can take screenshots if you want, and then just kind of make your own thing out of it. Okay, so we'll give that one. And I'll show you why this is relevant. Because best interest factors, court shall determine legal decision-making in parenting time, either originally or on petition for modification in accordance with the best interests of the child. The court shall consider all factors that are relevant to the child's physical and emotional well-being, including, number 1, the past, present, potential future relationship between the parent and child. So when you do this, you look for the best interest statutes. You put down number 1, what this is right here, and then you put down number 1, here it is. Daughter is familiar with father, has a strong bond with father, so much so that after 11 months of forced no contact between father and daughter in 2022, daughter rushed to father upon seeing father at second visit. Reports by supervising agency give detailed account of father's and daughter positive relationship. So my argument from past, present, potential future relationship between parent and child is strong bond, past relationship, present relationship, daughter rushed to father, future relationship is being, is detailed, and basically our bond is strong. Okay, now I just met the argument. Number 2, the interaction and interrelationship of the child with the child's parents or parents, the child's siblings, and any other person who may significantly affect the child's best interest. Okay. Number 2, daughter has been deprived of father's family by mother and years of false accusations and lack of co-parenting by mother. Daughter has a sibling that mother completely denied admitting to therapist. Mother has not allowed father any kind of time for father's side of the family to have a relationship with daughter. So there's the statute, relationship with siblings, and there's my argument, relationship with sibling, right? So this was in the petition, but in my arguments in court is where I stated, you'll see. So this was in the petition. All right, so we go to number 3. Number 3 is the child's adjustment to home, school, and community. All right. Number 3, daughter is adjusted and familiar with father's home, neighborhood, and community as expressed by detailed reports of daughter's willingness and eagerness to spend time with father for visits. Father has had a consistent home for daughter since her birth. There's the statute, and there's my reasoning and argument for it. Number 4. If the child is of suitable age and maturity, the wishes of the child as to legal decision making and parenting time. Okay. Daughter yearns for more time with father and reports consistently detail daughter's sadness at exchange when departing from father. Okay, so although my daughter isn't of suitable age to make this decision, however, she nonetheless is an individual with her own feelings and emotions, and I used this argument that she yearns for more time with father and backed by the supervising agency reports. So there's my argument. I could have said she's not of suitable age, or I could have added an argument, which is what I did instead. Oh, I didn't put I still left it up. There it is, right here. So, and here we go. So number 5, the mental and physical health of all individuals involved. All right, that's number 5. And number 5, the father has undergone 4 mental health evaluations during the history of the case, and the father is sound mind and without mental issues. This is the silliness that I've had to put up with. Mental evaluation after mental evaluation after mental evaluation. They actually asked for a 5th one. And the judge at that point in time was just like, no, because my argument was, what are we going to learn in a 5th mental health evaluation that we didn't learn from the previous 4? It's just nonsense. It's just an attorney tactic. That's all it is. That's all it is. Okay? These attorneys, you are nothing more than dollar signs to them. And when you have to work and do whatever it is to make money, don't you, especially if it's good money, don't you work your ass off? That's what they're doing. You are nothing to them. These attorneys, baby mamas, they mean nothing. You mean nothing to them. You are an ant that they would step on so eagerly and not give a damn about the children. They don't care. Accept it. You're dealing with terrible, terrible people. The attorneys, the baby mamas, they are awful people. So once you know that, you can't change, you can't reason with them. Well, if you're lucky enough to have a reasonable baby mama. Once you accept that, then take all emotion out of it and just work on your strategy. Okay? Just work on your strategy. Take out all emotion. Now that you know they don't give a damn about you. Not the courts, not the baby mama. They don't care. They don't care about you or the children, or else they wouldn't put the children through this. They are doing this, and they don't care. Once you accept that, work on your strategy. All right. So yes, I've done 4 mental health evaluations. So did the baby mama, and she's the one that came up with mental issues, and she's on antipsychotics, which is what it says here. Mother has a history of mental illness, is currently on antipsychotic medication, has continued to make irrational and poor decisions that warrants a current mental health evaluation. Daughter, as shown, has been recommended by professionals to have mental health assistance by way of therapists, which mother has failed in her legal decision-making authority to do so. Yeah, that was an argument that I brought up, that she failed and failed and failed her. But again, the courts don't care about the children. They don't care. They don't care about my daughter. They pretend that they do, but they don't. Because my daughter needed mental health assistance and the mother never got it for her. Specifically, recommendations that were made, she never did it. She put her in a group therapy for a few months and she thinks like that was enough. She doesn't care. I'm telling you, the mothers of the children that they are taking away from you don't care about your kids. You got to understand that that's very dangerous. These are not reasonable people. Okay, they don't care about your children. These women are psychopaths that are gonna put the kids in a vehicle and drive off a cliff if they find out that you have a new girlfriend or something. Okay, so only by court order did mother finally seek mental health for daughter. However, the mother's bias of her self-reporting false statements about father and failure to disclose information to therapists led to an improper and unethical treatment by the agency. Yeah, all of this is true. All of this is true, and I've shown it, but they don't care. The judge didn't care. None of the judges cared. They don't care. They don't care. They just want you to play their game. They just want you to play their game their way. Number 6. Which parent is more likely to allow a child frequent, meaningful, and continuing contact with the other parent? This paragraph does not apply if the court determines that the parent is acting in good faith to protect the child from witnessing an act of domestic violence or being a victim of domestic violence or child abuse. And this is so easy for them to prove when they have an attorney, when they say, oh, COVID, oh my God, they're not wearing a mask, oh my God, and then they deprive you of your kid. They can't do that. They can't do that. There was parents that did that. Mothers that would do that. I'm sorry, if there's anyone on here that feels that I'm showing bias in favor of men and against women, that's because the statistics say that women are more likely than do that. Sure, I've had a couple phone calls with women over their issues, but out of about 300 phone calls I've done, and only 2 of them have been women, so let's just say I have the right to be biased based on that. All right? So, ladies, no offense to you, but unless that evens out equally, I'm sorry. This is all for men and what women do to us. And if you're a woman that's on here helping your man, then you're a keeper. And I hope he knows that. And you're doing great for them. So, because what they go through is just absolute torment. So, in with the continuation of the argument, the mother has a history of making false claims, false accusations to deprive daughter from father, and is not likely to allow daughter frequent, meaningful, and continuing contact with the other parent. At every request that father has made for more parenting time, the mother has always contested with conflict and false claims. Mother claims to have acted in good faith, but once the truth has come out in court, the mother's claims have been dismissed several times since the last parenting time order. Since last legal decision-making order in 2017, mother has committed domestic violence in the form of attempted vehicular manslaughter on father's sister while daughter was inside vehicle. That was something that happened. That happened. It's true. But nothing was done about it. Women get away with everything. There's definitely 2 different justice systems. That, and I'm brown, so I'm sorry also. It just is what it is. Minorities get treated differently. Okay? I mean, if you don't like facts, you could just turn off my videos. Okay? And don't listen to them any further. But I give you facts here. Okay? So, I'm sorry. I'm going to be biased in favor of men, and the courts don't care about us, and there's definitely a different justice system for people of color. It is what it is. If you don't like it, get off the channel. Okay? Truth. All right. Number 8, whether there has been domestic violence or child abuse. Number 8, following along. Mother has attempted vehicular assault with child endangerment against father, sister, and daughter. This is something that happened. She tried to hit my sister with a car while they were in the front, in my parking space in front of the house. She tried to do that. She got all mad because she didn't know it was my sister, but we went to go drop off my daughter, and she didn't know who it was. She just knew it was a female, and she drove and followed me home, and then she started yelling at my sister, and she demanded she show her the car seat. She's a psychopath. And so then I just told my sister, just leave, just leave, just leave. And she tried to leave. And then that's when the baby mama tried to hit her with her car. And she was revving her engine and then speeding up and then hitting the brake. And she's just a psychopath, a psychopath. So that's what happened there. Number 9. The nature and extent of coercion or duress used by a parent in obtaining an agreement regarding legal decision making or parenting time. All right, I'm gonna continue on in the next video because I'm gonna cut these into segments because I realize this is gonna be like a 6-part series to go through this whole thing. So I'm gonna stop it now and then we're gonna continue. All right.